Go whenever you're ready.
So in Jana's case, there is an interesting situation because she was represented by a private attorney for most of her dependency and then what turned into a termination of parental rights case. The attorney that she had as the case began to get to trial, as oftentimes does in private cases when you have a private attorney, becomes expensive, and she was no longer able to afford the attorney. So the attorney withdrew from the case. She was appointed a court-appointed attorney, and the issues that she had with the court-appointed attorney dealt with evidence not coming forth as she wanted, witnesses not being able to come forth as she wanted, and the attorney's job is to be effective, assistantly to assist your client in such a way to allow them to present their case. Jana was having a bit of an issue with this, and she raised this with the court. She brought this up at her trial. She says, listen, this attorney isn't effective. In not so many words. And the judge essentially said, well, you don't have a right to an effective assistance of counsel. And the judge was right. At the time, there was no requirement that in a termination of parental rights case, a litigant who has a court-appointed attorney have the right to have that court-appointed attorney be effective. She goes through the trial, it doesn't go well, and when it comes time to appeal, she brings the issue up on appeal to the First District Court of Appeal, essentially saying, I did not have an effective attorney. My attorney didn't, last minute, came in, didn't know the evidence, didn't know the witnesses, and the appellate court did not address that issue. There have been other cases at the time that Jana's case came to the first DCA. There have been other cases brought to other DCAs, and other DCAs have said, we don't have any guidance from the Supreme Court. Are you entitled constitutionally to effective assistance of counsel? It just so happened about a year or so later, another dependency case, termination case came forward, and that case ended up going to the Supreme Court on exactly that issue. And the Supreme Court of Florida said, yes, you do have the right to effective assistance of counsel. It's not enough that the court appoints you an attorney. The attorney the court appoints you must be effective in order for you to have your constitutional right of counsel. The issue that Jana had was, well, this is great for people in the future as far as prospectively, but what about her case? What about retroactively? And the Supreme Court didn't say whether this was going to be applied retroactively or not. Constitutional rights can be applied retroactively. It requires what's called a retroactivity analysis to be done, where essentially it has to be something of such great importance that is worthy of retroactively applying it. One case recently dealt with that. It was dealing with death penalties and having the death penalty phase decided by a unanimous vote rather than a majority vote, and that ended up being retroactively applied. It's not been, that retroactivity analysis has not been done. Jana came back to the trial court again after that case came out and brought up the issue. The trial court did not apply the rule retroactively. It went to the First District Court of Appeal again, and again the First District Court of Appeal declined to apply it retroactively. So as she stands right now, although this is now the rule for the future and for other litigants who come before a court, they are entitled to effective assistance of counsel. But in Jana's case, because her case was decided a year or two before that case came out, she was deprived that right.